Welcome to Canton.Confidential, the Karen Reed murder retrial. There is now just one juror seat left to fill before opening statements can begin. Good evening, everyone. Thanks for joining us tonight. I'm J.C. Monahan.
And I'm Glenn Jones. Listen, it was a very busy day in Dedham. The court set 3 more jurors, bringing the total to 15. If the last panel member is seated tomorrow, it will pave the way for the trial to start next week.
Okay, we did get an answer from the Supreme Court on the defense's request to delay the retrial. On Monday, Reed's team submitted a stay of the state court of proceedings. Today, the High Court announced that justices have declined to take up that request. So what that means, full steam ahead once we have a jury.
However, the U.S. Supreme Court still has to decide whether it will take up Reed's appeal on double jeopardy grounds. Reed is trying to get 2 of her 3 charges dismissed, including murder. A SCOTUS conference is set for April 25th.
All right, let's bring you back to Dedham. It's been just over a week since the search for a jury got underway, and our John Maroney has been keeping tabs on the entire process at Norfolk Superior Court.
He joins us now with the latest on today's proceedings.
15, how does that feel?
It feels good. It feels good. It's almost the exact same pace as last year.
Karen Reed now has 15 jurors selected for her murder retrial. One shy of the magic number needed so testimony can begin, 16.
I feel good about all of them. I feel some I didn't, and they're not our jurors.
Reed has pleaded not guilty to hitting her boyfriend John O'Keefe with her SUV and leaving him to die in a blizzard. A group of 58 jurors in waiting was screened Wednesday. 84% of them said they've heard of the case. 47% say they formed an opinion, and 21% say they had a bias either for or against Karen Reed.
Ms. Reed starts this trial presumed to be innocent.
An alternate juror in trial number 1, Victoria George, is now helping the defense to select a jury. Chris Dearborn is a former public defender and professor at Suffolk Law School.
There's a perspective that that person can bring to this case that is unparalleled.
Doing this film is my testimony.
Reed has given a number of interviews, including as part of a new docuseries about her first trial. Special prosecutor Hank Brennan is looking to introduce portions of the series at trial.
And some of those are coming, right? And I think that is, that could be a problem for the defense.
Leaving the courthouse, the defendant said she was just learning of the Supreme Court's decision to consider her appeal in 2 weeks.
And I only just heard about the Supreme Court from you folks. And I'm waiting to get in the car and reconnoiter and find out exactly what it means.
That date is April 25th, and on that day, the U.S. Supreme Court says that it will at least consider the case. It has already said that it will not stay or delay the start of the state trial. In Dedham, John Maroney, NBC 10 Boston.
We are joined now by commentator Sue O'Connell. So let's get on this whole idea of the jury pool. You were in the courtroom as well as John.
Yep.
If we break it down so far by gender, it's split now, 8 men, 7 women. Does it matter? Do we want a perfect balance? What?
Yeah, at this point, it doesn't matter because we don't know where we're going to end up. And Judge Cannoni has also said if we are in court tomorrow and we get that magic number 1 juror very early, we got one early today, she's going to continue through the day and stack the deck, if you will, and get as many jurors seated as possible. So the number, of course, is this, but who knows? It could end up being bigger. That's what happened last time. And then in the end, we ended up with 14 with a gender split, 6 men, 6 women, and we'll just see how it shakes out. So that's right now. It's important to think from a big perspective, but we just don't know where we're going to end up at the end of the trial.
Right.
Well, how about a step beyond just gender? I understand there was a young adult sat on the jury today. Is that unusual when compared to the other jury in the first trial, or any other similarities or differences?
So what I have seen while I've been in there and looking at the jurors is they remarkably resemble in many ways the first jurors that I have seen. Wow. So there was a young juror last time who I remember thinking she went up there peppy. This is the first trial, and then her face started to fall as she realized, oh my gosh, I'm actually going to be in the whole trial. She sat in the front row like, I can't believe I'm sitting here. And this young woman I saw today was also like the second person called up, and she went up to the judge, and then you see her face looking around like, oh, they're going to keep me. I can't believe this is happening. So, yeah, I think the gravity of this is a murder trial. There's a dead police officer, John O'Keefe. Karen's on trial for her life. So the gravity does come in. But it will be interesting to see if the jurors resemble in some ways the first jurors from the first trial.
Our courtroom insider, Sue O'Connell. Thank you.
You're welcome.
Thank you. All right, Karen Reed's defense team will argue that two men had the motive, the means, and the opportunity to attack John O'Keefe the night of his death. One of them is ATF agent Brian Higgins.
He's a meaningful figure because he's 1 degree removed from key players in this case: the victim, the homeowners, even the defendant.
Yes, I do.
ATF agent Brian Higgins.
I'm a special agent with the United States Department of Justice, Bureau of Alcohol, Tobacco, Firearms, and Explosives.
On the witness stand during the first trial, along with Brian Albert, he's expected to be named by Reed's lawyers as a third-party culprit in the second trial. That means the defense believes Higgins could be culpable in John O'Keefe's death in late January of 2022.
You recall those dates?
I do.
You've been living with those dates for the last couple of years.
Like a nightmare.
On that night, surveillance video shows Higgins at the same bar as Karen and John. He even texted Reed that night. While she did not respond to that text,
Defendant responded, "You're hot."
other messages confirm Agent Higgins was physically attracted to the defendant.
I responded, "Are you serious or messing with me?"
He even shared a kiss with her.
Defendant responded, "No, I'm serious." I responded, "Feeling is mutual. Is that bad?" On a personal level, I kind of keep things to myself. I was a little embarrassed. Wasn't really proud of him. Kind of maybe didn't show me in a good light with respects that I was John's friend.
After the bar, Higgins went to the party at 34 Fairview, the home of Brian Albert. The two Bryans are friends. Although phone records indicate a connected call between them on the night John O'Keefe was killed, both say they didn't speak. Following the after-party, Agent Higgins was caught on a surveillance camera right outside Canton Police Headquarters. That's according to the defense. That video likely came from the church right next door. The video was not used in the first trial, but is likely to be used in the retrial. It reportedly shows Agent Higgins on a cell phone call, perhaps the same cell phone he famously threw into a dumpster.
You lost all of your other text messages besides the ones that you had with Karen Reed and John O'Keefe, correct?
That's correct.
And you knew that you did have text messages on that old phone with Kevin Albert.
He's a friend, most likely.
And you had text messages on your phone with Brian Albert.
Yes.
Higgins admits he used an FBI device to download text messages from his personal phone, then handed them over to investigators. The defense alleges self-selecting which messages to download was suspicious, and using an FBI device to do it was improper. Later, Higgins disposed of that phone on a U.S. military base near his property in Barnstable County.
You knew that that destroyed SIM card and the phone would be gone forever, correct?
Yes, I threw it away.
And before you drove away, you did not transfer anything from your old phone to the new phone, correct?
That's correct.
We don't know if Agent Higgins faced an internal review at ATF related to the Reed case. We requested internal investigation documents, current employment status, and any disciplinary action. The response 5 months later was silent on all three. Here's how Higgins explained his employment status on the stand.
I'm assigned to division operations at this time.
Okay, what does that mean?
That's...
You're taken out of the field?
Was I taken out of the field? Yes.
We've tried to find out if Higgins still works at ATF, even requested his payroll records. We've gotten nowhere on any of that. Lastly, and it's very important to note, only Karen Reed has been charged in the death of John O'Keefe.
All right, let's welcome in Michael Coyne, our trusted legal advisor through this entire process. Can you help explain the defense's attack this time of a third-party culprit? What is that exactly? What do they have to prove?
Yeah, it actually starts with the idea that what an opening statement and a closing argument is. Lawyers only get to talk to the jury during the opening statement and the closing arguments. The opening statement, when they are addressing the jury, it is supposed to be about what the evidence will indicate throughout the trial, what they're going to introduce. And then in the closing argument, you get to argue what that evidence that's been introduced at trial means. In order to argue the third-party culprit defense, which simply means it wasn't this defendant, there are others who are responsible for it. And in this case, they're trying to argue that Brian Higgins and Brian Albert were the people responsible for it. In order to argue that, they have to introduce concrete evidence that would show the means, the motive, and the opportunity to actually kill John O'Keefe.
So my issue with that is they insinuated all that in the first trial. So how do you differentiate it this time? Because this time they can name the names, but what else can they put forth? They
can't name the names during the opening statements.
Right.
What she said is that I assume that when the foundation is laid, that they can show through admissible evidence the items that would link them to this event. Now, part of it may well be Higgins, at least in part, flirting with the defendant, her flirting back. Does that provide him a motive to kill John O'Keefe? The roughhousing in the bar that night, did that somehow transfer to John O'Keefe as well? That's not going to be enough to get them there. Somehow, there has to be some testimony that shows him going inside the house, because that's where the crime allegedly takes place. And that's going to be tough, because the only person that says she saw him go into the house was the defendant, and I don't see the defendant testifying under any circumstances.
And on top of all of that, Michael, we're so much better informed now. We know that a federal investigation took place. There were no indictments handed down as a result of that. We've seen the Canton Police Department audit pretty much comes back clean in terms of there being any conspiracy or anything like that. So doesn't that water down their likelihood of success with a third-party culprit defense?
It absolutely does. And I think this is where they may be making a mistake. It's a very tough sell. A dozen people somehow involved in a cover-up for a murder, and then when we decide to inflict such grievous injury on them, we throw them on the front stairway, not stairway, but the yard of the house. And the fact is that that's a tough sell. The first jury had trouble getting to that. That's why they got to 9-3 to convict. I think they're assuming a burden they don't have to. They can defend this case on the basis of reasonable doubt. All the various holes that we've talked about many, many times that everyone sees. But so why have to try and assume a burden to convince the jury that he's killed inside the house when there's a little evidence to support it? Instead, do a reasonable doubt case. Use the sloppiness of the night, the sloppiness of the police investigation, and the accidents happen argument. I think you've got a reasonable doubt case. I don't think they're going to be able to offer enough evidence to support the idea that the two Bryans committed this act and then put him out on the front yard of the house. It's a very difficult burden they have.
Yeah. Well, it's interesting. I mean, they could still change course and go in a different direction, more in line of reasonable doubt, and kind of leave this culprit defense behind.
I would reasonable doubt, and that she's a scapegoat. Forget the framed argument as well. Scapegoat is easier. Because of the sloppiness of all the procedures and the investigation itself, we needed someone to put the rap on. She was convenient enough in her desperation. She even thought she might have done it. She became an easy scapegoat. To me, it's a better argument that may more likely resonate with the jury than the third-party culprit defense.
It's the cleanest.
It is cleaner.
I mean, if you stick to that narrative.
Well, again, remember, the government's burden of proof is beyond a reasonable doubt. Everyone who's looked at this case knows that there are holes, big holes in this case. Play on that instead of assuming a burden that you're not obligated to assume.
Michael Coyne, Dean of the Massachusetts School of Law. Sorry for cutting you off.
I wanted to thank him, too.
I liked it. We always thank you.
Thank you.
All right, remember, NBC 10 Boston, we are your source for everything related to the Karen Read trial. Be sure to join us weeknights at 7 for a full recap of the day's court proceedings.
Tomorrow night, we're also looking into another man Read's defense team believes could be culpable in John O'Keefe's death, retired Boston police detective Brian Albert. O'Keefe was found dead outside Albert's former Canton home.
Okay, and don't forget, if you have questions, and I think we all do about this case, send them our way. We have the email right there on your screen. We will answer as many questions as we can right here on Canton Confidential.